All right, so exceptions to Title VII of the Civil Rights Act of 1964. So this is back to the kind of concept of if we're going to like not promote you or something like that. So if someone says, you didn't promote me based on my race, you can say, no, I didn't promote you based on merit, meaning the person I did promote was a better employee than you. Okay, so what's your first impulse when I say that? I can defend against an accusation of discrimination by saying my promotion was based on merit. What would your concern be? How do you prove merit? Other ways, like if somebody had consistently better performance appraisals, that helps. Although you could say, well, you always appraise this person lower because they're a minority, right? You systematically discriminated against the minority. Could it be something that's a little less like subjective to the boss, like customer service appraisals? Like, maybe like if they were going to promote me here, maybe they could look at my student feedback in addition to some metric like DFW rate, like my students pass my classes better than other teachers. So that's what employers are kind of left to do is you start to come up with these measures that mix the subjective, like an employee employment appraisal, together with objective measures like, even something as simple as like how often they clock in late. That's something you can measure. That has nothing to do with anybody's gender or race. This person has been late 5 times in the last year, and this person hasn't been late at all. This person has a higher customer service rating than this person. This person has fewer, fewer errors if they're on a production line, or whatever. Those would be merit-based things that would be an exception to Title VII. You could promote them based on the fact that they're a superior worker. You just have to be careful that you do so in a reasonable way. Seniority, who's been here the longest? What's the problem with seniority promotions? Some people, doesn't matter if they've been there longer. Some people just aren't worth promoting because they're just taking up space. I mean, hopefully not, but that happens. Anybody ever worked with someone who's been there longer than you, who you're thinking, you've been here 5 years and I've been here a week and I'm already as good as you? There's a problem. That's happened to you? It happens. It was actually my frustration when I was in the military, because we're all salaried, so you get paid based on your rank. And it didn't matter if someone was kind of worthless or someone worked really hard, you all got paid the same, and that was frustrating to me. The Bona Fide Occupational Qualification, or Bfoq. So here you can say, I'm going to hire somebody who's a male for this job because I have to have a male for this job. And you better be able to prove that you really have to have a male for this job. Usually it's harder to say I want to hire a male, but that's usually a better defense or exception for things like disparate impact claims. Like the whole, I have to lift 100 pounds over my head. Yes, that impacts women more than it impacts men, but if you can show, come see the job, it involves lifting 100 pounds over your head, I have to have that requirement. So that is a bona fide occupational qualification, the ability to lift 100 pounds over your head. This sometimes comes into play. There's a pretty interesting lawsuit with a Hooters, because they had a certain bona fide occupational qualification to be a waitress at their store. In essence, they went to court because someone said, you didn't hire me, and why didn't you hire me? And they said, because you didn't fit the image of a Hooters waitress. And the person said, that's discrimination. First of all, bust size is not a protected class. Gender is, but not bust size. So that made it hard for them to really have a case. Secondly, in essence, what Hooters said is, look at our business model. You might find it distasteful or inappropriate, but nonetheless, people who come here expect a certain thing, and we want to deliver a certain thing. It's part of our business model. And it got thrown out. Okay, I mean, sometimes the law has to be blind to whether or not you or me or the judge thinks it's sort of distasteful. This is more about with someone legally, disqualified from a job or illegally disqualified from a job. And then another exception is something called affirmative action. Can anybody tell me what affirmative action is? Yeah, Bryson. Right. So it's or it's completely racism depending on your standpoint, right? Yeah, that's the thing that's hard about affirmative action. So the idea behind affirmative action is that it establishes quotas for hiring based on race or gender to sort of correct past, past inequalities. Okay, so maybe a place says, look, 40% of our community is African American, but only 20% of our police officers are African American. So as we hire, we are going to hire more African American officers until we get some parity there with the community at large. Okay, and the courts have said that's legal. You could discriminate against white or Hispanic applicants in favor of African American applicants in that situation because it falls under an affirmative action program. And again, it doesn't matter if you like it or don't like it. Usually the person who doesn't get the job because of it doesn't like it, but there's been a legal precedent set for it. Okay, yeah. Mm-hmm. You're right. So there is a shift that is shifting away from sort of just blanket affirmative action. Now it's more like there's the courts are looking for like more tests of like, is there a reason for this? Is there a lack of parity here that still needs to be adjusted? Where it used to just be like blacks were discriminated against in the past, so now or Hispanics or whatever group. So there's a shift. But what's important for this class is recognizing that we may be allowed to discriminate on the basis of race or gender if there is a reasonable affirmative action plan in place that states this is what we're doing and why. Okay. All right. And then this is less than an exception, but a defense. Companies can defend themselves against sexual harassment cases if they exercise reasonable care to prevent and correct harassment, meaning in essence they have a policy about it and they actually follow that policy. So that if, say, somebody turns in a complaint of sexual harassment to the management then looks at what the policy is and follows it, goes and reprimands the person who does it, and offers counseling to the person who was a victim of it, and and if the person does it again, they fire him or whatever. So if they exercise reasonable care, and if the plaintiff unreasonably fails to take advantage of the preventative or corrective opportunities, meaning like if you'd gone to your boss would have done this and that, but you didn't go to your boss. So what happens here is when somebody then files a complaint, the EEOC comes in and looks at it and says, did you do all these things? And if the answer is like, no, I didn't follow my company's policy in reporting this, then they're going to say your company's not really liable because they've shown that they do everything in their power to keep you safe, but you didn't do your part. Whereas if they report it and then management doesn't act and then they go file a complaint, now management's in trouble. The reason this defense is important is because the person who harasses you is always liable. Okay, because they harassed you, you could sue them. But the company is only liable if they didn't take some reasonable care to prevent it or deal with it if it was reported. Okay, so it doesn't always have to be reporting even, because it could be prevention too. Like let's just say that there's a bunch of stuff going on, everybody always knows about it, and the company doesn't do anything about it. Even without the report, you could say you didn't take any care to prevent this from happening.